Good morning. I would like to call this meeting to order. Thank you for joining us during our weekly virtual Emers breakfast meeting today. My name is Pauline Lam of Cotai Realty. A few housekeeping tips. All participants will be muted. Should you have a question or a comment, please enter it into the chat box, and the host will read it during the question and answer portion of the meeting. Please remember to join us weekly, as we will have our virtual Emers breakfast meeting on every Thursday at 9 a.m. As always, this meeting is being recorded and will be available online on our YouTube channel, West San Gabriel Valley Realtors. A little about me. My name is Pauline Lam. I'm your May Emers meeting program chair. Please remember to follow WSGVR social media on Facebook, Twitter, and Instagram. You can also watch all our pre-recorded videos on YouTube. WSGVR now offers text message updates. Please text the word WSGVAR to the number 313131. Today's agenda consists of our President's message given by our 2020 President Mindy Ye, and followed by our guest speaker, Hutchinson, who is the Assistant General Counsel of CAR. Let's welcome President's message. Mindy.
Thank you, Pauline. Good morning, WSGVR family and guests. I'm Mindy Ye, your 2020 President. Wishing all moms, grandmoms, a happy Mother's Day this Sunday, May 12th, and appreciation to all the brave nurses in our community that have been working tirelessly to take care of our loved ones during National Nurse Week. Thank you for attending our virtual MLS breakfast meeting and for your continuous support as a valuable member of the West San Gabriel Valley Realtors. Please do not hesitate to reach out to our leadership team and staff. I would also like to thank our guest speaker today, Hutchinson, CAR Vice President and Assistant General Counsel. CAR and associations are hard at work to help members through pandemic and economic recovery. Focusing on strength and resilience of Californians, CAR this week launched a new ad campaign to serve as a tribute to people who live here. Airing statewide between May 4th through July 6th, the new campaign highlights how hard Californians are working to keep our state safe, to keep our lives moving, and to keep our side focused on building a better future. Red alerts was emailed out by CAR to all of you on Tuesday, May 5th. I urge you to please take action ASAP, oppose AB 828. Urge your state senator to vote no on rent reduction bill. California senators are scheduled to vote on AB 828 this Monday, May 11. Should a tenant claim they are affected by COVID-19, AB 828 gave judges the power to reduce rents by 25%. You and your client play an essential role in CAR ability to defeat dangerous legislations like AB 828. Please ask your family and clients to call the senators and the author of the bill, Assembly Member Ting, ASAP, or before this Friday, May 8th, at 916-319-2019, and state that you are strongly opposed to his bill and will destroy rental housing. California COVID-19 Economic Market Update, Wednesday, May 6th. Jordan Levine, CAR Deputy Chief Economist, shared with us the following. Other recorded records were breaking: biggest drop in housing starts since 1984, largest decline in builder segmenting ever. Empire Manufacturing Index drops to the lowest level. ever, industrial production at the lowest level since 1946, UA's Fed index at lowest level in 40 years, nearly 5 million households in forbearance. Short-run estimate of COVID-19 impacts. Economy will shrink by 30 to 40% in quarter two. Unemployment expected to exceed 20%. Double digits decline for California home sales. Declines expected to persist for May, maybe June. Price impacted expected to remain in single digits. Mortgage credits remains difficult to obtain. Big wild card is the virus. Second wave means worse numbers. The latest economic pulse flash survey from the National Association of Realtors shows that the trends haven't changed drastically from the week before. Sellers, for example, aren't budging on price. More than 3 in 4 realtors are working with sellers right now. Of those, 76% says their clients have not reduced listing price in order to attract buyers, an increase from last week's 74%. Realtors continue to learn on technologies helping during this time. However, the focus has shifted to video. 30% of surveyors, realtors have to complete nearly all transactions processed while participating social distance. Future clients, the most used tattoos are live videos at 53%, e-closing technology, 46%, messaging apps, 41%, WebEx, Zoom, 32%, virtual tours, 27%, social media, 18%, and e-signing, 8%. This is still a significant group. However, 41% who says some transactions aspects still require person-to-person interaction with safety precautions being taken. WSGVR elections of board of directors. Candidate package has been emailed to our members again this past Tuesday. There are up to 6 director positions available. Deadline to submit your completed candidate form is in 2 weeks from today, May 21st by 5 p.m. Due to COVID-19, elections will be held on July 30th instead of June. I hope you continue participating to social distance, stay healthy, stay strong, and stay connected. Please join us next Thursday, May 14 at 9 a.m. Our guest speaker will be Michael Brooks, tax attorney with Direct. Additional information will be available by the end of this week. Thank you, Pauline.
Thank you, Mindy. Now it's my great honor to introduce our special speaker today, Mr. Goff Hutchinson. He is the Assistant General Counsel of CAR. He is very famous, well-known, and we're so happy to have you today. Let's give our warm welcome to Goff for your presentation of legal updates. Here is Goff.
All right, thank you very much. I can't hear you clapping, but I know you're all clapping. Thank you very much. I wish I was there in person. Thank you. I wish I was there in person so we could all be eating donuts together, but unfortunately, we have to be remote for now. First of all, yes, happy Mother's Day coming up. And rumor has it that yesterday was Mindy's birthday, so happy birthday, Mindy. You look younger than ever, of course. Anyway, let me talk about what's going on. I'm going to give you a legal update, what you need to know about doing real estate under the coronavirus. I mean, the good news is, as you know, real estate is considered an essential service. Some people can't work right now, but realtors can work. It's an essential service. You're allowed to work, but you cannot work like you used to. Temporarily, we have to follow special rules and use special forms to be legally okay, all right? In other words, we're essential, but we have to follow the guidelines, the best practices. CAR took all the required best practices and turned them into a best practices document that you all have available for you on the website of car.org. But to really make it easy for you, we turned the best practices into a couple of forms. So if you use the forms I'm about to talk about, you are definitely following the rules. And if you're following the rules, you're not going to get in trouble. Nobody can sue you. Your errors and omissions insurance will cover you. Everybody stays safe and healthy. So it's a really good idea. What am I talking about? Well, you know what I'm talking about. If you're going to show real estate now, it's only got to be one agent and 2 buyers at a time. Everybody has to stand 6 feet apart. Everybody should be wearing their gloves. Everyone should be wearing their mask, and even things on your on the booties on your feet if they're available. When you go into the house, you don't touch anything. You stay 6 feet apart. And then when you leave, the listing or the seller or the listing agent wipes down all the surfaces, anything that might have been touched during the showing, okay? Not only that, anytime you do a showing, everybody who comes into the house and the seller and the listing agent, everybody is supposed to sign this form. It's called the PEAD form. That stands for Property Entry and Advisory and Declaration. Yes, thank you very much. You can see it down there. PEAD, Coronavirus Property Entry Advisory and Declaration. Every buyer, buyer's agent, appraiser, inspector, stager, photographer, anybody who enters the property should sign the form, and the listing agent and the seller sign one too. Now, you only need one form per day. So if I'm a buyer and I'm going to look at 3 houses today, I sign a PEAD, I put my name on it, I date it, and I put the addresses that I'm going to go visit today. And every time I go into a house, I give it to the listing agent so they get a copy. The listing agent is supposed to collect a copy from everyone who enters the property. Now, maybe I don't want to tell I don't want to tell the listing agent the other properties I'm going to be looking at today. In that case, I just use one separate PEAD for every entry I do today. So I have one for this property, one for this property, one for this property. Tomorrow, I need a new PEAD, dated tomorrow. Every day you have to have a fresh one dated today. And the reason for that is because here's what that form says. When I'm the buyer and I sign that form, I'm telling you, I promise I'm going to follow all the rules. And I also promise to you that as far as I know, I am not sick. I have no symptoms of being sick with COVID-19. And as far as I know, I have not been in contact with someone for the last 14 days who I know has COVID-19. So yes, you have to put your address, the address of the property you're going to. But what I said is, if I'm going to go in 3 different houses today, I could put all 3 addresses on the same form and just give copies of that form to each listing agent, or I could just use a separate form with a separate address each time I go into a property today. But tomorrow, even if I go into the same property tomorrow, I need a new PEAD form dated tomorrow, because you know what? Between today and tomorrow, my health situation may have changed. So the listing agent, the seller are always entitled to a fresh daily PEAD form where I'm telling you about my health situation today. Once again, I promise I'm going to follow the rules. You know what else it says? It says, I assume the risk. This is not completely risk-free. Some people don't know they're sick. Some people hide the fact that they're sick and they were in the property before I was. I don't know. You never know. Sometimes the seller doesn't know if they're sick, or the listing, nobody knows for sure, right? So everybody tries the best they can. They wear the mask. You stand apart. The seller wipes down the property after each showing. And that's why the seller and the listing agent should also sign this form. Because by signing this form, the seller and the listing agent are saying, as far as I know, I'm not sick, no contact with anyone who's sick, I have no symptoms, and I promise that I've wiped down the property, disinfected it since the last visit, and I'm going to wipe it down after this visit, okay? So everyone is agreeing to this, and everybody agrees on this form that the realtor, that if I do something wrong, I'm going against the realtor's advice, I assume the risk, and that basically means that if something goes wrong, the realtor is not responsible, and you're protected, okay? So that's a really good form to use, the PEAD. Everyone should sign the form. And you know what? You see there's a form right under that, PEAD-LR. If any of you guys are a landlord or a property manager, and you're going to be showing properties to prospective tenants, you would use the PEAD-LR. That stands for lease rental. So I got one, excuse me, for showing sales property and one for showing rental property. Now there's another form right under that, you can see on your screen, the RLA-CAA. That's another really good form I want you to use. This is, in other words, you're going to use this form before you even do the PEAD. If you're the listing agent, you're going to ask your seller to sign that RLA-CAA. That's the Coronavirus Addendum to the Listing Agreement. And on that, if I'm a broker and I give this to my seller and say, please sign this, the seller is promising when they sign this that they're going to follow all the proper procedures. They're only going to let people onto the property who've signed the PEAD. They're going to wipe it down after each showing, and they indemnify the listing agent. You know what that means? That means they promise if something goes wrong, if there's any lawsuit that comes out of this activity, and if the realtor gets sued, the seller says, I will indemnify you. I will take responsibility. So you're covered, your E&O covers you, your clients have to indemnify you. Plus on this form, I'm talking about the RLA-CAA, that's the form where the seller tells you, yeah, I want you to put up a sign, or I don't want you to put up a sign. I want you to do a virtual tour or not a virtual tour. So they tell you what type of marketing they want you to do. And they also say if they're going to allow inspections. I mean, some sellers, you know, in this day and age, if they're so worried that even though they're allowed to have people in the property, they don't want anyone in the property. They say, I want you to do the whole sale virtually. And you say, well, how can we do that? You know, if the buyer can't come in the property, if the inspector can't come in the property, it's going to be hard to sell. But nevertheless, the seller can do that. And then you have to say to this, it says right on the form, if the seller does that, it's going to be, they understand it's going to be harder to sell the house. Another thing, what if the seller says, I don't want you to come in the house? And you say, I need to come in to do my visual inspection and fill out my AVID form. And the seller says, no, I don't want anybody to come in. Well, how do you do your AVID form if you can't even come in the property? Well, you can fill out the AVID form and say, you know what, I was not given access to the property. My disclosure is based on what the seller told me. My disclosure is based on the pictures or the videos the seller showed me, but I was not able to get into the property. But nevertheless, this is what I have to say. And by the way, on our website, car.org, we have something called quick guides. It's a one-page explanation of something. All you have to go is car.org, and in the search box, you just type in quick guides. For example, we have quick guide to showing property, to doing a visual inspection in the coronavirus. We have a quick guide to dealing with tenants who won't allow you in. So we have language you can put on your AVID form or your contract when that happens. So that's just another resource for you that you can do. Okay, so I've talked about two forms, or actually three forms, the PEAD, the PEAD-LR, and the RLA-CAA. Now, the next form I want to talk about is the form at the top of your list there, the CVA, the Coronavirus Addendum. Now, this is not a mandatory form, but I think it's a good idea to use this form. You know what this form says? This form says, this is like an addendum to the purchase contract. So on this form, the buyer and seller are agreeing, you know, in the coronavirus situation, sometimes things take longer than normal. Sometimes lenders are taking more time than normal. Sometimes it takes time to get the appraiser out there, to get the notary out there, to get the inspector out there. Or sometimes the buyer, someone in their house gets sick, that delays things, or maybe the seller loses their job or something. Sometimes something's going to happen that's going to delay the transaction. Well, if you use this form, the CVA form, as an amendment to your contract, the buyer and seller agree on the form that if something happens during escrow related to the COVID-19 that causes a delay, the buyer and seller are automatically agreeing up front that there's an automatic extension of 30 days. and we have one, see right under that, for leases also, CVA-LR for lease rental. So we have an addendum to that. We have you can use that form for sales or for rentals. Now, using the form for sales, let's say I'm the buyer and you're the seller, right? So I write an offer and I attach this addendum, you agree. So we both agree that if something happens during escrow, like a delay, there's an automatic 30-day extension. Of course, at the time we enter into the contract, we don't know for sure if this is going to happen. But let's say now, once we get into escrow, and here I am in escrow, the buyer, and all of a sudden I realize the lender's so slow because of this delay that I'm not going to be able to remove my contingencies on time, or I've already removed my contingencies, but the lender's going to be late funding or something like that. In other words, or I have to take care of my niece or something who got sick and that's going to delay me or something like this. Well, now I'm going to send you the form on your screen that says NUCC, Notice of Unforeseen Coronavirus Circumstance. In other words, I'm the buyer. We have both agreed to the CVA. Now I realize, yep, there is a delay. So I'm going to send you this form telling you, you know, we were anticipating a problem, and guess what? We do have a problem. The lender's backed up. So by giving you this form, as soon as you receive it, that triggers the 30-day extension that we agreed to. Okay, now we both agree to the extension automatically because I sent you that form. So you see what I mean? The NUCC works together with the CVA form. So the CVA form is the buyer and seller agree to it to anticipate the problem. And then once we do have a problem, if we do, then I send you the buyer sends the seller, or the seller sends the buyer, or the landlord sends the tenant, or the tenant sends the landlord, the delay on the lease. What would be the delay on the lease? Well, maybe the tenant and the landlord agreed to the lease, but then something happened that's going to delay the tenant's ability to move in, the occupancy, or something affected the landlord, and it's going to affect their ability to have the property ready. But we anticipated this with the CVA-LR. We anticipated that something could happen, and then if something does happen, either the landlord or the tenant would send the NUCC-LR. Okay, so what about if this happens? What if something happens in escrow, like the buyer loses their job, or the seller loses their job and they don't want to sell anymore? Well, how do we deal with that? Well, you can use this form too, because this you could send the NUCC and say, I lost my job, so we want to cancel the deal. In other words, on the CVA form, you can actually check a box right up front that says if something happens, then if something like that happens, I want to cancel the whole deal. Okay, so the next question is, if something happens to you like that in escrow, you lose your job or something, after you've removed your contingencies, so you send them this form to cancel the deal, does the buyer get their deposit back, or does the seller keep the buyer's deposit as liquidated damages? And the answer to that question depends on what box did you check on the CVA. Because the CVA, there's a box that says, you know, if you absolutely cannot perform, even with an extension, you cannot perform, it says either side can cancel and the buyer gets their deposit back. Or you can check a box that says, no, if this happens, the seller keeps the buyer's deposit. So of course, I know what you're thinking. The buyer wants to get their deposit back and the seller wants to keep it. So what if the buyer doesn't want to check the box where they lose their deposit and the seller says, no, I'm not going to agree to this form unless we check the box that says I get the buyer's deposit? Well, you know what? If that's the case, you're not going to use this form because the buyer and seller don't agree. You see what I'm saying? This form, I mean, it's a nice form, and I think it's a good form, but you're not always going to use it if the buyer and seller won't even agree. Which leads me to the next question. Let's say you don't use the CVA form. You just have a regular purchase contract. Halfway through escrow, the buyer, they remove their contingencies, and then they lose their job. Okay, then they've lost their job. and the buyer says, I'm sorry, I lost my job related to COVID-19, so I can't buy your house. So are they going to get their deposit back, or is the seller going to keep the deposit? And so you didn't use the form, right? Well, then it's going to go to court, and the judge is going to decide, does the buyer get their money back, or is the seller going to keep it? Normally, if the buyer removed their contingency, the judge is going to say, sorry, buyer, you lose your deposit. But in the pandemic that we're in, there's a law in California. It's called Civil Code 1511. And it says in that law that if you're in a contract with someone and there's some big thing that happens that's completely outside of your control, you couldn't anticipate it. The law actually says if your performance of your contractual obligation is prevented by an irresistible superhuman cause. Some people call this the act of God law. Then you don't have to perform and you don't have any legal consequence. So the question is, are the courts going to consider this pandemic an irresistible superhuman cause, and they're going to allow people to get out of a contract without consequence? We don't know yet, right? And it might depend on the situation. It might depend on what exactly happened. Did you get sick? Did you lose your job? Or do you have to take care of? I mean, it might depend on what it is. So some courts are going to say, yep, buyer, get your money back. Some are going to say, no, you don't. My point is, if you want to avoid going to court where you don't know what's going to happen, you can use the CVA form to anticipate this. And the buyer and seller can agree up front, if something happens, then what's going to happen? If something related to COVID-19 happens, what is the consequence? So you can anticipate it and do it yourself if you want to. Now, people are asking, how do we have to use these forms forever? No, you're not going to use these forms forever, but for the time being, I think they're good forms. For example, you know that the governor is opening up the state gradually. You may not know this, but we're in phase 1 now, and phase 2 starts tomorrow, Friday. And phase 2 says there's certain businesses that can open tomorrow, like a florist or something like that, bookstores, but you still can't go in without a mask, and you're supposed to just take things to go and not shop around. So it's going to gradually open up. Maybe phase 3 or phase 4, they're going to say you can do open houses, but you can't now. Maybe phase 3 or phase 4 is going to say more than 2 people can go into a property at once. That's not happening yet. Maybe phase 3 or 4 is going to say you don't have to wear a mask every time you go in the property. But it looks like to me, I bet none of that stuff's going to change until like phase 4 at the earliest. So I think for the time being, in real estate, we got to get used to using these forms, wearing the mask, staying 6 feet apart, 2 buyers and 1 agent per showing, no open house, no broker caravan, no gatherings, and I think we'll be good for now. Okay? All right. Next thing I want to talk about is rental properties. Some of you may be landlords. Some of you may be tenants. Some of you may be property managers. What do you need to know? There's a couple things you need to know. First of all, in California right now, there's an eviction moratorium. What does that mean? That means if I'm a landlord and I have a tenant, and the tenant can't pay their rent, and the reason they can't pay their rent is because they have a loss of income based on COVID-19. Either they got sick or they got laid off or something like that. If that's the reason why they didn't pay the rent this month, I cannot evict them until June 1st. All right. Now, the law also says, though, that the only way this is true is if the tenant can prove to the landlord that the reason they didn't pay their rent is because of COVID-19. So that takes me to the last 2 forms I'm going to talk about on your screen there. You see the form that says NTAP, Notice of Tenant of Ability to Pay Rent. If I'm a landlord, here we are, May 7th, and let's say I didn't get my rent on May 1st. I'm going to send this form to my tenant and say, hey, tenant, I noticed you didn't pay the rent. Well, remember, it's not like you don't have to pay the rent. If you don't want me to evict you, you have to tell me in writing why you didn't pay the rent and prove to me that it was related to COVID-19, which takes me down to the last bottom form on your screen, the RPD. That's the form that the tenant responds and says, okay, the reason I didn't pay the rent is because of COVID-19, and I'm going to attach to this form some proof, like, you know, like a notice from my doctor or a note from my employer that I got laid off or something like that. All right. Now, if you send that to me, then that tells me, the landlord, I can't evict you for now. But what about on June 1st? So far, this eviction moratorium only goes to June 1st. So if my tenant doesn't pay me on June 1st, okay, tenant, you got to pay me, and you got to pay the back rent too, or else I'm going to evict you. Well, that's what the law says. But then it gets more complicated, because there are a couple of other things we need to know. Let's say I'm the landlord, right? And the rental property that I'm renting to my tenant, the loan that I have against the loan that I got to buy this property that I'm now renting, if the loan I got was an FHA loan, a VA loan, or a conforming loan that's been serviced by Fannie Mae or Freddie Mac, if that's the case, there's a nationwide eviction moratorium that lasts till July 25th. So it's not June 1st, it's July 25th, depending on what type of financing the landlord has on their property. If they have any federally related financing, then I can't evict until July 25th, not June 1st. That still means the tenant has to pay me back in full all the back rent. Now, maybe I want to give them a break and set up a repayment plan, or maybe I'm going to say you owe me all the rent, either on June 1st or July 25th, depending on what type of financing I have on my property. But then it gets more complicated. Whatever type of property it is, there's a different thing that happened in California. The court system shut down. The court system is closed right now for certain type of lawsuits. Judy Chow, yes, Fannie and Freddie is federal financing. So right now, in other words, even if I have a legal right to evict someone, I mean, let's say I'm a landlord and I just want to get rid of my tenant, give them a 60-day notice because I don't like my tenant, or I'm going to sell the house and I need the tenant out to sell the house, right? So of course I'm allowed to give them a 60-day notice, right? Sure. So I give my tenant a 60-day notice. 60 days from today is like July 7th or something, and they don't leave. Well, now what do I do? Well, the same problem. The courts are closed. So I will not be able to evict my tenant 60 days from now. Yes, Eric, this applies to commercial landlords. I'm going to do most of the questions at the end, but a couple of them I may just answer as I go. So no matter what the situation, I cannot evict someone in California until August 1st at the earliest. But that doesn't mean the tenant doesn't owe me the money. They got to pay me back in full immediately. Unless I live in a city like Los Angeles. And I don't know if any cities in West San Gabriel Valley or San Gabriel Valley are like Los Angeles. But you know what Los Angeles says? Not only can you not evict the tenant until August 1st, but they have 12 months to pay you back the back rent if the reason they didn't pay was related to COVID-19. Now, that's not a state law, that's a Los Angeles law. So city of Pasadena, city of San Gabriel, any city around there, I don't know if your cities have any special rules like that. We can check for you. And we actually have a chart on our website, car.org. If you go there and in the search box, you just type in eviction moratorium chart, and it'll pull up a chart that will show you all the cities in California that have passed their own rules. LA for sure. I don't know about any other cities around where you guys are, okay? So you see how complicated this is? There's a state eviction moratorium. There's a nationwide eviction moratorium. The courts are closed, and some cities are even stricter. You know what else the city of LA did and some other cities have done? They've said during the coronavirus, no landlord can raise their rent at all. Whether you're under rent control or not under rent control, if you're a Los Angeles landlord, rent freeze. Once again, I don't know if any cities around you are. Now, did you hear what Mindy talked about in her president's message? There's a proposed law out there, AB 828, that she mentioned that would say, hey, landlord, the tenant doesn't have to pay you back all the back rent. The court can reduce by 25% the amount of money they owe you. And as CAR is opposed to that. We don't think that should be right. We don't think landlords should have to, it's bad enough that landlords have to delay getting their money, but they shouldn't have to forgive 25% of their rent. So that's why she pointed out that if you get a red alert, please call your state senator, right? Please call your state senator and tell them you're against AB 828. We don't think it's going to pass because we have there's a lot of people opposed to it, but I just want you to know that that's out there. That's what Mindy was talking about. And that's the red alert that we all want you to call your senator if you get that message, okay? All right, next topic, let's talk about foreclosures. Not only is there an eviction moratorium, there's a foreclosure moratorium. What does that mean? That means if you get behind on your mortgage payment, you can't get foreclosed on until June 23rd. Okay, June 23rd, no foreclosures in California. Okay, but does that mean if I don't make my mortgage payment for April and May and June, on June 24th, can they foreclose on me for all the mortgage payments I missed? Yes. The statewide foreclosure moratorium doesn't mean you can delay making your payments. It just means you can't get foreclosed on until June 23rd. But there's something else going on called foreclosure forbearance. That's different than just a foreclosure moratorium. Remember how I said a couple minutes ago that if the property owner has the loan that they use to buy the property is a Fannie or a Freddie or an FHA or a VA, federal government related loan, and that restricted your ability to evict someone? Well, guess what? Same thing. Those type of loans, the lender has to give you a forbearance. You know what that means? That means not only can they not foreclose on you until June 23rd, but you don't have to make up those back payments right away. There's no like lump sum balloon payment you gotta pay on June 24th. If you have a federally related loan on your residential property, you know, once the forbearance is, you can apply for a 6-month forbearance, which means you don't have to pay the mortgage payments that you missed. They have to be restructured, either repayment plan, loan modification, or just add on those payments, you know, to a later date, like 6 months or 12 months from now. It's not like you don't have to pay it back. It's just that you don't have to pay it back right away if you can't make your mortgage payments because of COVID-19, health issue, loss of job, something like that, or your tenant's not paying you the rent. That would be something too. Okay, so for that you got to go, you know, you apply for that through your lender, but they have to give you that forbearance if it's a federally related loan. If it's not that type of loan, you just borrowed money from a bank, or, you know, or Wells Fargo or Citibank, or you borrowed money directly from some local lender, they don't have to give you a forbearance. They don't have to delay the time period you have to make up the back payments. They just can't foreclose on you until June 23rd. Okay, you see what I'm saying? So it's obviously all this stuff is temporary and it's kind of complicated, but we got to deal with it for the time being. Okay, next topic. So that's the big thing. I told you about the rules you have to follow in real estate right now. I told you about the forms you should use and the forms you can use if you want. I told you about the new rules for evictions. I told you about the new rules for foreclosures, right? All of this is temporary, but we got to deal with it right now. Let's talk about a couple other things. What about the Department of Real Estate? Well, the good news for realtors is if you have any debt, first of all, the DRE is closed right now, but I think they're going to open up May 15th as far as giving exams again for new people who want to get a license. But let's say you have a deadline to renew your license, right? Let's say my license must be renewed by July 1st or something like that. If you have a deadline coming up between now and July 14th, that deadline is automatically extended 60 days. So if you're supposed to renew your license on July 1st, your new deadline is August 29th, right? 60 days later. What if my deadline is July 20th? Well, your deadline is still July 20th because your deadline is after July 14th. You see what I'm saying? So that's the latest on the Department of Real Estate. You know what else is going on? What about 1031 exchanges? You know how that works? Let's say I have a income property or a commercial property and I want to sell it, but I don't want to pay the capital gains tax right now. So what can I do? I can exchange, I can sell one and buy another one. And once I sell the first one, I got 45 days to identify the second one and then 180 days to close it. But you know what? Those deadlines have also been extended. Those deadlines have also been extended till July 15th, okay? Yes, someone just asked, is this the same slide? Yes, I don't know if we have any other slides. That was the important slide for all the forms. I'm not talking about the forms, but I don't have any more slides, okay? Anyway, so we covered DRE, we understand 1031 exchanges, right? What else should you know? Well, a couple more things. First of all, people keep asking about disclosure questions. If the seller or on the house you're selling, or the tenant in the house you're selling, or the former tenant on the property that you're now going to lease, if they are sick with COVID-19, do you have to disclose that to the buyer or to the new tenant? Do you have to disclose that the prior occupant was sick? And the answer is yes, you do. Some people say, oh no, that's private medical information. Having a contagious disease is not private medical information. That must be disclosed to the new buyer or the new tenant, right? So you have to disclose that, right? It's a disclosure fact. I'll tell you something else. What about this? What about this? What about the, you have a buyer, right? A prospective buyer is coming into the house to look at it, and they sign the PEAD form, and that form says, you know, I'm not sick, I have no symptoms, I had no contact with anyone who's sick, right? So the buyer signs that form, goes and looks at the property. 3 days later, this buyer is sick with COVID-19, which means 3 days before, they probably were sick too, they just didn't know it. You know, that buyer is supposed to go back to the listing agent and say, you know what, I didn't think I was sick, but turns out I'm sick. So that means the next thing that's going to happen is the listing agent has to now disclose to everyone to the best of their ability, anyone who came onto the property after that buyer 3 days ago, who you now found out was sick, you got to go back to them and said, you know, you entered the property after someone else had been on the property who now we think was sick at the time. Of course, if everyone was wearing gloves and a mask and 6 feet apart and the seller wiped down all the surfaces like they're supposed to, I don't think there was much risk there, but that's still a disclosure obligation that you have to do under COVID-19, okay? See how there are disclosure issues here that you got to deal with? Okay, let me talk about a couple more things, okay? And then I'll take all your questions. First of all, I'll be happy to tell you that I have a couple things to tell you that have nothing to do with COVID-19, right? Seems like all we talk about these days in the legal world is COVID-19 because it's very important. But there are a couple of other things that are happening in real estate that you should know about that have nothing to do with COVID-19. So I'll talk about that for a second, okay? One thing is, you know, CAR comes out with new forms twice a year, June and December. Now, the forms I talked about before, those were emergency forms, right? They came out, we came out with them in March and April because we're in an emergency. But going back to the regular schedule, we are going to have a couple new forms coming out a month from now in June. And these forms, I think you probably are going to like them. They're good forms. They protect the realtor. One of them is called the Property Visit and Open House Advisory, PVOH, Property Visit Open House Advisory. This is not required by law. It's a good form. Here's the idea. You know that a lot of houses now have hidden cameras and hidden microphones. So when you go into somebody's house, you never really know if you're being recorded or not, right? So you know what happens sometimes? Realtors show a house to a buyer, they go in there and they find out later they're recorded. And then they get mad at the realtor and they sue the realtor. Now, the CAR listing form, on that form, the seller promises that they are going to disclose by putting up a sign or something if the property has any hidden cameras or microphones. But some sellers don't do that anyway. So the purpose of this form, the PVOH, the Property Visit Open House Advisory, whether someone's coming on an open house, which we can't have now, or just any viewing, you're going to give this form to the buyer. You know what it says? The buyer says, I understand that when I'm going into this property, I may be recorded, I may be under video, so I understand that, I accept that risk. And it also says on this form, the buyer says, I also understand anytime I go on someone else's property I'm not familiar with, you know, I have to be careful about the stairs and the hill in the backyard or the bump in the carpet. And they're basically accepting the risk, which means if they trip and fall or something, they can't go after the realtor. Why didn't you tell me about the step over there? Well, I gave you that form. You acknowledge you accepted the risk of going into the property. You promised you were going to be careful. And you promised you're going to watch your kids too. You're going to make sure your minor children aren't running around getting in trouble either. So it's a good form to protect the realtor. And the second brand new form that's coming in is called the Square Foot and Lot Size Advisory. Remember, these are new forms. They're not out yet. They're coming out in June. That's why you don't have them on your screen. They're just brand new. So this form called the Square Foot and Lot Size Advisory. Have you ever noticed that if people have a different opinion on square footage? The assessor thinks it's one number, the MLS thinks it's a different number, the appraiser thinks it's a different number, the seller thinks it's a different number, the agent thinks it's a different number, the architect thinks it's a different number. Everybody has a different opinion on what the square footage of this house is. So the question is, who's right? And the answer is nobody's right and nobody's wrong. Everybody's opinion is as good as anybody else. There's no such thing as official square footage. There's no official government agency. There's no official standard for how to measure it. So the purpose of this form is, I'm an agent, I'm going to give it to my buyer and say, you asked me what the square footage is, here's the answer. I'm going to give you this form, and on this form there's a chart, and you write in what does the assessor say, what does the appraiser say, what does the seller say. You're basically saying, here, these are the different opinions as to the square footage. And buyer, I encourage you to investigate on your own, hire your own person to measure square footage. But any square footage that I told you was, you know, here's where I got the information. No one's guaranteeing the square footage is what somebody says it is. There are different opinions. There's no official definition. So here's a chart telling you what everybody thinks. Because you know what happens all the time? The realtor buyer says, how much is the square footage? And the realtor says, 2,200. Then the buyer moves in later and says, no, it turns out it wasn't 2,200, it was 1,900. So I'm going to sue you for the difference. Well, they won't be able to if you give them this form, because this form, they're acknowledging you didn't tell them that this is the square footage. There are various opinions and you disclose that, okay? And it also affects lot size. People say, what's the lot size? And you say, the only way to know the lot size for sure is to get a survey. So I encourage you to get a survey. Not only that, there's no guarantee that that fence over there is on the boundary line. There's no guarantee that those hedges over there are on the boundary line. Nobody knows until you do a survey. I'm not guaranteeing anything. So I encourage you to get a survey if you're curious about that. So once again, these two forms I think are good. They're going to be just helpful to prevent lawsuits against realtors, which is a good thing. So those are the only two new forms coming out. Are there any forms you have that are going to, that you already use that are going to change? Well, remember I told you, I think last year, that if you give someone a 3-day notice,
this is a call.
pay or quit.
What did he try to do with his boxes?
Mute them.
Okay, I need to know if you unassigned it or did you transfer them to us? Because I don't see it in Supra.
There is a
Not
note.
what you got to mute everybody.
Wendy, and it says box number 57.
There we go. Good job. Anyway, you know how when you give someone a 3-day notice to pay or quit now, that the 3 days, you don't count weekends and holidays. So that terminology is going to be right on the notice to pay or quit, right? It's going to explain that you count the 3 days differently. So that's something. You know what else is changing? We have something which I think you all know about. Effective on May 1st is this clear cooperation rule, right? Where if you have a listing, as soon as there's any public marketing, it's supposed to go onto the MLS the next business day, right? In other words, you're not supposed to have these coming soons where you take the listing and you're marketing it, but it's not on the MLS for a month or so. Basically, the rule is what I just said. If you do any public marketing, as soon as you do that, it's got to go on the MLS by the next day. The only exception to that is you could market it within your own brokerage. In other words, you could tell the other agents in that brokerage about this listing, and those agents can individually, one-on-one, expose this listing to their own clients. The point is, this is now explained on this will be starting in June on your listing contract, your residential listing agreement. It'll be explained there, okay? Also, there's a form called the SELM. That's if the seller wants to exclude the listing from the MLS. SELM, seller excluding listing from MLS. That form is also going to be modified to explain what I just talked about. Okay? You're asking good questions. I'm going to get your questions in a second. But the last thing I want to talk about before I get your questions are, there's something good out there that you realtors should know about, which is you are entitled to relief. You're entitled to money under these government programs. There are 3 government programs out there. One is called PPP, Payroll Protection Program. One is called the EIDL, Economic Injury Disaster Loan. And the last one is called PUA, Pandemic Unemployment Assistance, okay? Pandemic Unemployment Assistance. I'm not the expert on these. We have experts. First of all, there's a phone number I want to give you. You know the legal hotline number? There's a new special hotline just to answer your questions about these programs. And that phone number is 213-351-8450. I'll put it in the chat later, 213-351-8450. Plus, we have a new special website, car.org/coronavirus. So if you go there, there are FAQs. And if you call that number, 213-351-8450, people will help you. Here's what I'm talking about. The PPP, Payroll Protection Program, either a broker or an agent, you can apply for this loan to basically pay for 2 months worth of expenses or 2 months worth of reduced income you have based on COVID-19. And the good thing about this loan is you don't have to pay it back. It's a forgivable loan and you have to, but it's only going to cover basically 2 months worth of expenses for the broker, like mortgage, rent, payroll, stuff like that. Or if you're an agent, it replaces 2 weeks worth of lost income based on COVID-19, but you got to use the money by July 1st, and there's a limited amount you can get. Second thing, the EIDL, maybe I'm a broker, I own a business, and this COVID-19 is hurting my business, so I want to get a low interest loan to help me pay off some debts or deal with payroll or mortgage or anything like that. And I need more than 2 months worth, and I might need it beyond July 1st. Well, in that case, I can apply for this EIDL, Economic Injury Disaster Loan, and I may be eligible as part of this program to get a grant of up to $10,000 that I don't have to pay back. So that's a possibility too. The problem with those two programs is they keep running out of money. Have you noticed? You read in the paper? So the Congress has to go back and put more money in the program. So if you call that number, they'll tell you the status and how to do that. But the third thing might be the best for you if you're a realtor. It's called PUA, Pandemic Unemployment Assistance. And the way this works is, even though you're an independent contractor, you can get unemployment. Normally, if you're an independent contractor, you don't get unemployment. But under this program, you do. So anyway, how does this work? Well, if you're a realtor, we sent you an email last week with a step-by-step guide how to fill out the application to get the unemployment. But if you didn't get that email for some reason from California Association of Realtors, or you look at it and you don't understand how to fill out the application, you have questions, call that phone number I gave you, 213-351-8450, and people can help you fill out that application. We know a lot of realtors who have already got it and they got certified to get the money. They're going to mail you a debit card, and then you're going to be able to get the money. Well, how much money am I going to get? Well, of course, if you're still making money, if you're still making commissions, you're not going to get the unemployment. But maybe if you're not getting paid, or you're not getting paid as much as you did before, then you're going to be eligible for this money. And it's retroactive back to February 1st. For the month of February and March, it'll be $167 a week or a little more than that. But for April, May, June, and July, it's going to be at least $767 per week. And then after that, August, September, you may, if it's still around, if you still need it, you'll be getting less money. But the point is, you're going to get this money if you have a reduction in income. This is unemployment. Usually independent contractors don't get unemployment. Here's a way you are going to get unemployment just in this current situation, okay? Don't ask me too many questions on this part, because remember, that's why we have special hotline with experts. I'm an expert on the legal stuff, but I'm giving you the big picture, right? To help you with these programs, which you are eligible for. You might as well take advantage of it. You've heard some of these big rich companies are getting these forgivable loans. You should get them too, or at least get unemployment if COVID-19 is affecting your ability to make your income like you used to. And I'm sure it is affecting a lot of people's ability, so you should apply for it. All right? Now, let me do questions. I mean, I can read them right off the chat for myself, or someone wants to read it to me. I can, what do you think, Mindy or Pauline or Ling? I can just read them myself if you want me to. What do you think? Ling says okay. Mindy says okay, right? All right, so I'm gonna answer your questions, and you can keep asking. I'll stay as long as you want for me to answer these questions, okay? So I'm gonna go back to the beginning of the meeting and take your questions. First, everyone's saying happy birthday, Mindy, happy birthday, Mindy. Cecilia asked me, no property address. Yes, you do have to put a property address on the PEAD. Definitely. You can either put one property address, or you can put all the properties you're going to go on to today, but the PEAD form does have to have a property address on it. Brian Chen asks, the top of the form says you have to use the form each time you enter the property. So if I show the property in the morning and I go back on with the same buyers in the afternoon of the same day, do I need a new one? No. Remember, the form you used today is fine all day today. And if it's the same address, if the same people want to see the same property more than once in a day, you don't even have to change the address, right? It's the same. So yes, today you just need one form for everybody. Okay. Cecilia, I think I answered the question. Do you need the CVA for leases also? Remember, the question isn't whether you need it, is whether you want it. The good thing about the CVA is that enables you to anticipate delays that might occur, and you can, you can agree to an extension right up front. You don't have to wait for the problem to do the extension. Diana Velez, does the NUCC need to be acknowledged by the seller? Good question. Remember what I said? If I'm the buyer, you're the seller, we're in escrow, we sign the CVA with this automatic extension, and then something happens, so I send you this form to tell you, yep, it happened, so now the automatic extension kicks in. Of course, some sellers are going to say, I didn't get your message, I didn't get it. So of course, ideally, yes. Just like everything you do in real estate, any form you send to anybody in real estate, you want them to acknowledge it, make them say, yes, I got it, because otherwise they always say, I didn't get it, I don't know what you're talking about. So yes, you do want the acknowledgement. Very good question, Nanette. Does the listing agent need to give the buyer's agent the form? Very good question. Here's what the rules say. Buyer's agent and buyer and anyone else, when you enter the property, not only do you have to sign the PEAD, you must give a copy to the listing agent. So the question is, does the listing agent have to give the buyer's agent a copy? The rules say you don't have to. But if I'm the buyer's agent, I'm entitled to say to the seller, the listing agent, could I please see your PEAD form that you signed? And I might say, in fact, could you please give me a copy for my file? And if they say that, listing agent, give it to them. I'm just saying the guidelines don't require the listing agent to give a copy, but if the buyer or the buyer's agent wants it, I think they're entitled to it, because you don't have to go into the property. You want to know if the seller's going to tell you, yes, I cleaned the property since the last time, and yes, I'm not sick or anything like that. So you're certainly entitled to see it, and you're entitled to a copy of it if you want to. It's just not automatic that the listing agent and the seller has to give it to them. Judy Chow, I think you answered your question. Yes, Fannie or Freddie financing is considered federal financing for purposes of the eviction moratorium until July 25th and the foreclosure forbearance on those types of loans. I think I answered Eric's question about commercial landlords. This unlawful, I mean, the eviction moratorium doesn't apply to commercial properties, but the courts being closed until August 1st for any unlawful detainers, yes, that applies to commercial. Sarah Nova, the court is closed for certain types of lawsuits. What about disability suits? I think those lawsuits can still proceed right now. Mario, how can a lender servicer help? You can always negotiate with your lender to delay and defer mortgage payments. Remember, if it's a federally related loan, they have to negotiate. They cannot require a full payment on whenever the forbearance is over. So they pretty much have to work with you. If it's just a direct loan with a lender, they don't have to work with you, but they can if they want to. The servicer has to work with you. Cecilia asked me 1031, when does the extension start ticking? Remember what I said is 1031 exchange, all deadlines are delayed till July 15th. So it's not like, when does it start ticking? If you currently have a deadline, if you currently have either a deadline, the 45 days to identify the replacement property or 180 days to close it, if you already are in the middle of a 1031 exchange and you have a deadline, that deadline is, all deadlines are now July 15th. So it's not a question of when does it start ticking, it's just, it ends on July the 15th, okay? Juliana too is giving me a good tip on escrow holder, blah, blah, blah. Do whatever Juliana says about escrow. She knows what she's talking about. she's my boss, so do whatever she says, okay? Take care of the escrow companies, blah, blah, blah. Okay, Joe Haggerty, when I say lenders can't foreclose until June 23rd, do I mean they can't even start the process, or do I mean that they can't actually do the sale? That's a very good question, and the answer is not crystal clear. Since the answer is not crystal clear, the answer we're giving is yes, don't even start the process. Because if you start if a lender starts the process prior to June 23rd, I wouldn't be just surprised and say some judge is going to say, oh no, you shouldn't have even started. So you got to start all over. So if I'm advising a lender, I'm saying don't even do the notice of default until June 23rd. And remember, if it's federally related loan, residential property, then you can't, you know, it's different, right? It's there's a forbearance, you can't start the foreclosure at all. Nanette, if the seller doesn't want to sign the CVA, is the buyer on the hook then? Remember what I said my example was? We don't know how courts, if you don't use the CVA and the buyer for some reason, let's say they get sick or they lose their job and they can't perform, are they going to get their deposit back or not if you don't use the form? My gut feeling is they will get their money back, but we don't know for sure how the courts are going to deal with this. So that's why I say the advantage of the CVA is at least you can determine up front who gets the money or split the money or whatever, so you don't have to wait for a court to decide. But in other words, to answer your question, even if you don't use the CVA, I think there's a good chance the buyers, if they really have a legitimate reason related to COVID-19 that they couldn't close, I think they're probably going to get their money back anyway. Karen's asking me what's the square foot and lot size advisory abbreviation. That's the SFLS, square footage lot size advisory, coming out in June. Jim's asking me, how about putting a sign in front of grandma's house merely to snag phone calls? Nope, that's considered public marketing. Don't do that. No signs, blah, blah, blah. Marcus, same question. Square footage disclosure form is the SFLS, square foot and lot size advisory. What's the, Janet Chan, what's the camera microphone form abbreviation? That is PVOH, property visit open house advisory. But remember, it's not just open houses. I would give this, once this form comes out in May, I'm going to give this one more form. I'm going to give every single buyer and say, you know, just read this, be careful, understand that when you go into someone's house, you never know if you're being recorded or not. So whether it's an open house or just a regular showing, I would give this form just for your own protection. Mindy, yes, she's giving you the phone number to call about that bad law that we were both talking about, the AB 828. That's the one that says that if that law got passed, then the courts would be able to tell a landlord, you have to cut your rent. You have to reduce your rent during the time of the COVID-19. So we are opposed to that. We don't think any government should be able to tell a landlord, I mean, rent control is legal. Whether you like it or not, the courts have said it's legal for the government to limit how much you can charge someone as far as an increase. But there's no way we should allow courts to tell landlords they have to, you have to reduce your rent. You know, so I don't think it's going to pass, but we need you to make your phone calls. And even if it does pass, I don't think it would survive a court case. I think it's unconstitutional, but be that as it may. Jim Vega, yes, we are against socialism. I'm not sure exactly what you mean, unless that's just what I'm talking about. Raymond, good question. Is CAR doing anything to challenge the Judicial Council's emergency rules? What he's referring to is the fact that the courts are closed. And they're not just closed for unlawful detainers, they're closed for a lot of other things too. You know what else? The criminal system is closed. Sometimes if you know, here's the good news for all you potential criminals out there. If you get arrested for a misdemeanor today, your bail is 0. So any of you that are ever thinking about committing a crime, now is the time to do it, because you can't be held over into jail unless you commit a felony, okay? I'm kidding, of course, but no, Ray, I don't think CAR is doing anything specifically to try to challenge that. Thank you, Mindy, for putting the COVID relief hotline, 213-351-8450. Patty, the square footage form again, SFLS, square foot and lot size advisory. Paul Cheng, no, AB 828 is proposed, but I think, as Mindy mentioned, I think they're going to vote on it Monday. Even if it gets, we don't think it's going to pass. We're not sure the governor's going to sign it, and we don't think it's going to be, as soon as, if it ever gets passed, there's going to be an immediate lawsuit, and I don't think it's going to, it's not going to survive, but we still got to, please make the phone call if they ask you to. Patty Cheng, I think you can see the phone number. Mindy put it up there, 213-351-8450. John Wax, I got good news for all your realtors. Remember how the purchase contract was supposed to be changed this year? It's been postponed for a whole year. The RPA is not going to be updated until December 2021. Andy, on the bottom of the Pead form, after everyone signs an initial, does seller have to initial too? Well, it just depends on how it works, right? I mean, we all want people to acknowledge receipt. So buyer signs the PEAD, gives it to the listing agent, and the listing agent acknowledges receipt. But of course, maybe the seller wants a copy too, right? Either the listing agent is going to give it to the seller, or the buyer is going to give it directly to the seller. I mean, or maybe listing agent, you want to make, when you give a copy to the seller, you want to make sure they acknowledge receipt. It's whatever you want. I mean, yes, everyone should probably just give these forms to everybody. Everybody acknowledge receipt so everybody knows they got it. I mean, you know what I mean? But the rule says the form must be signed by anyone entering the property, and that must be given to the listing agent. And the listing agent can hold it for the seller, give it to the seller. And remember what I said before, the listing agent and the seller are supposed to sign their own. And if the buyer wants one, give it to them. And then you probably want the buyer or buyer's agent to acknowledge receipt. Gary Pan, yes, construction is essential. You can do construction. Hi, Vanessa. Hi, Ling Chow. What are you asking about? What about new contractors like Lennar? I mean, new construction, right, is what you're asking about. I mean, you know how new construction is. They use their own forms, and they're going to do whatever they want sometimes. But I think if I was a builder, I would require people to use the PEAD form. And even if they don't require it, if I were you, a buyer going onto a property, I would still follow the best practices. If the builder doesn't want you to give them a PEAD form, don't give it to them. But I mean, that's what's supposed to be happening. And you as a buyer's agent, I think you should still get your buyer to sign it and give it to you, so your buyer is agreeing to follow the rules. Helen, if the tenant notifies a landlord that they're impacted and asks for reduced rent, remember, you're not entitled to reduced rent. All you're entitled to is delay on getting evicted. But unless you live in like a city of Los Angeles, you have no delay on paying the rent. There's just a delay on evictions till August 1st. And even in LA, it's not like they don't have to pay the rent back. It's just they have 12 months to pay it. So there's no such thing as reduced rent, but some cities allow you to delay rent, okay? But you're right. If the buyer cannot prove that the reason they're delaying the rent is because they lost income because of COVID-19, then they're not allowed, even in Los Angeles, they're not allowed to delay. And remember, if you're not in Los Angeles, there's an eviction moratorium, but there's no delay beyond that on repaying the rent, okay? Can you stage the property in this part of, yes, LA County, staging is considered to be essential enough. Karen, if the buyer's agent asks listing agent for the listing agent's PAD, yes, listing agent should give him a copy. What about, another good question from Jim Vega about evictions. Can I start the process, or should I not even give them a notice until the, don't even give them the notice, okay? To be safe, don't even give them the notice till, remember, this eviction moratorium only lasts till June 1st. So you don't have to wait till August 1st to give them the notice. It's just you're not going to be able to get a court date. But don't give them the notice until at least June 1st. But I'm talking about if they don't pay the rent. If, let's say someone is just not moving out, right? Because, you know, you give them a 60-day notice, they refuse to leave. It's got nothing to do with COVID-19. In that case, yeah, you can give them a 60-day notice right now. The only thing I'm saying is don't give them a 3-day notice to pay or quit until at least June 1st, okay? But everything else, you can give them the notice now. Nanette, I missed the part about the courts on the CVA. The point I was making is if you don't use a CVA form, we're not sure if courts are going to allow buyers to get out of their deals if it's a COVID-19 reason, or it might depend on what the reason is, okay? Earl Knutson, advertising of listing agent is not on listing agreement. I'm not sure what you mean by that. You mean advertising someone else's listing? If that's what you're asking, yeah, you cannot advertise someone else's listing without their permission. So yes, if that's not your question, maybe you can ask it again. Yes, Juliana, let's keep the escrow companies in business. I agree. What about buyer agent schedules home inspection to inspect? Does the agent need to provide the PAD form to the inspector? Yes. Everyone who enters the property, inspector, appraiser, buyer, agent, painter, photographer, everybody should sign a PEAD form. Mindy, one of my clients rented a room to Airbnb and now they're not leaving, right? You know, the problem is with these Airbnbs, first of all, you can threaten to sue them. They say, if you don't leave, I'm going to sue you for damages. I'm going to sue you for thousands of dollars. You're not allowed to be in my property. But can you legally evict the Airbnb? You know, probably not until August, but you can sue them for absolutely not just the amount of money they should be paying, but they can also be sued for damages if that affects your ability to sell the house or something like that. You might try law enforcement. I've heard of some law enforcement in some places. They don't treat Airbnb people like regular tenants, so they'll just kick them out. But it depends on the law enforcement. Sherry, what type of loan relate to federal? Remember, if the landlord's property that you're renting out is securing a federally related loan, that means it's a Fannie Mae, Freddie Mac service loan, it's an FHA or VA loan, or even if it's a Section 8 subsidy loan. If you're in any of those federally related situations, you can't, there's a nationwide eviction moratorium until July 25th, but who cares anyway? The courts are closed till August 1st anyway. So everyone should just think in your mind, in California, August 1st, okay? Karen, yes, zero bail, go out and commit a crime. They can't make you stay in jail overnight, as long as it's a misdemeanor. Of course, once they convict you, then you'll go to jail, so don't do it, okay? Just kidding. Yes, happy birthday, Mindy. I think she's 23 years old today, right, Mindy? Okay. Teresa, should you use the RPD on commercial rentals? I mean, good question. You don't have to. Here's what I said. The eviction moratorium doesn't apply to commercial, but the courts being closed for unlawful detainers now that applies to commercial evictions also. But you don't really have to use the RPD with commercial. Brian Chen, did I say 3-day notice? Yes. the 3-day notice right is going to make clear that the days, what we're talking about, are business days, not calendar days. Andy, good question. You know, the best practices obviously is the buyer and the realtor drive separate cars to meet at the property. But yeah, if the buyer has no ride, you could tell them take a bus, take an Uber, make them sit in the back seat. I mean, it's not like you're going to go to jail for this, but the best practices is that you don't share the vehicle. It's up to you if you want to take that risk. If your buyer wants to take that risk, I don't advise it, but it's really up to you. Mindy, when can landlord increase tenants' rent for City of Riverside? Like I said, I'd have to check the chart. There's a bunch of cities in California, not a bunch, there's a few cities in California that currently have a rent freeze, like Los Angeles. I really don't think Riverside is one of them, but I'm not sure. Bottom line, call the legal hotline or go to car.org and search for eviction moratorium chart. You guys have a lot of questions, don't you? That's okay. Kazu Hamada, I don't know if I pronounced that right. Yes, you should use the PEAD form on vacant land. Yes. Karen, landlord needs to sign a PEAD even though it's a listing agent showing the property. I guess that the landlord is never ever setting foot on the property, right? I would still make them sign a PEAD form. You know why? Because it's the landlord's obligation to be the one who wipes down the property after each showing, right? So maybe they're going to delegate that to the listing agent, but if I'm a buyer, I still would probably want to see, I want the landlord to commit in writing that they wipe down the property every time. Judy, what about the non-paying tenants or receiving unemployment? That's a good point. In other words, the tenant says, I can't pay the rent because of COVID-19. You say, yeah, but you're getting unemployment. Good question. I think if they can prove they lost their job, they're still probably going to get away with. But remember, it's not that they don't have to pay rent, it's just that you can't evict them. And as I keep saying over and over again, you can't evict them anyway till August 1st. And on August 1st, they owe you all the back rent. Whether they got unemployment or not, they owe you all the back rent unless nothing. In City of LA, they may have extra time to pay it, but that doesn't mean they don't owe it. Alex, what if my tenant paid only 2/3 of the rent? Yeah, good question. Some tenants, they're making partial payments, not complete payments. You should still use the NTAP and the RPD. Is there government support for the tenant to pay rent? People are talking about that. That may happen, not yet. Karen, yeah, good question. I should talk about this real quick. By the way, I'll hang out here for at least 10 more minutes. What Karen Asher is asking, and I should have mentioned this already, there's going to be a proposition on the ballot. We don't know the number yet, but there's going to be a proposition on the ballot in November supported by CAR, which says if you're over 55, you can move from your current house to any other house in California and transfer the property tax you're paying on this house to the new house, whether the new house is more expensive or less expensive than the old house. Now, if the new house is more expensive than the old house, you're going to have to pay more than you're paying now, but not nearly as much as you'd have to pay if you just moved to a real expensive house and got reassessed. So sort of be a blended rate. Remember, the current law says you can only do this if you move within the same county. You can only do it once, and the new house has to be cheaper than the old house. If this gets passed, you can do it not just in this county, you can go to any county, and you can do it 3 times, and the new house can even be more expensive than the old house. On the other hand, the reason this is going to probably pass now as opposed to last year's is the thing that some people don't like about this proposition is it would say that if a parent transferred income property to their kid, that property would get reassessed. Whereas nowadays, any time a parent or grandparent transfers property to their children, it never gets reassessed. If this new proposition passed, that would only be true if you transfer property and your kid uses it as their primary residence. But Karen, don't ask me why, because I'm not CAR, I just work for you. Your board of directors voted for this and approved this, so it's official CAR. I mean, you guys as individuals don't have to be for it or against it, but CAR did pass it. So I just wanted to explain to you that was the decision the board of directors made. And you know what, I'll tell you something. People say, oh, I don't like the fact that parents can no longer transfer properties to their kids without getting reassessed. Well, you know what's happening right now? Under this COVID-19, as you probably know, states and cities are running out of money because they got to pay for all these things like unemployment they didn't have to pay for. So you know what's going to happen? States and cities are going to be looking for ways to raise taxes. And you know what they're going to do? Whether this proposition gets passed or not, we've already heard talk from the legislators in Sacramento that they want to get rid of the exemption from reassessment for intergenerational transfers. So we're hoping this proposition may preempt that. You see what I'm saying? And may actually limit it so you can at least still transfer your primary residence to your children without any increase in property tax. So the government's already thinking about this, whether we do this proposition or not. The good thing would be at least is if everyone can, if people over 55 can move without moving their, because that's going to encourage people to move, right? That's going to create more transactions. And realtors, you should be happy to be getting more transactions. Okay, Ling, we got like 3 more minutes here. Can force majeure be enforced in a construction contract? Yeah, probably, if it's in there. When are realtors going to be able to go back to work in the office? Very good question. The answer is not yet. As of now, you're still not allowed to go back to an office unless it's essential. And the point being, since you can basically do your job virtually, there's no reason why you're not allowed to, there's no reason why you should go back to the office. 1 or 2 people should go to the office to collect the mail, to turn off the lights, to turn off the utilities. But as a group, realtors are not allowed to all go back to your office and start working there. Susan, what if the owner's not able to wipe down the property? Then the listing agent should do it. All right. Split roll, good question. You know what split roll means? There's a movement out there that CAR is opposed to, that would say, to put a proposition on the ballot that would say commercial properties are no longer protected by Prop 13. And that means that if you own a commercial property, your property tax go up indefinitely. CAR is opposed to that, but the good news is they haven't even got enough signatures to get it on the ballot yet. If they do, we'll be opposed, okay? Okay, I think I got 1 or 2 more. Cecilia, tenant owns a rental property out of state. Our tenant says he can't pay us. He can't prove it's COVID related. Well, that means you can evict him right now, except for the fact that the courts are closed. So what can I tell you? August 1st. Is it buyer's agent's responsibility to wipe down everything if the listing agent is not at the property? You know how I'd respond to that? You should not have your lockbox set up or your key safe set up so that people can see the property without the listing agent. You got to do it by appointment only, so you're there. So you make sure that people who come in have the PEAD form, and you also make sure that the seller or the listing agent is going to wipe down the property. You shouldn't be the listing agent should not be letting you into the property without an appointment. Okay? All right. I think I'm done.
Thank you so much. Thank you, Bob, for
My pleasure.
Thank you very much. We're so happy and appreciate for your treasure time with us today. And on behalf of Western Gabriel Valley Realtors, we want to like to thank Mr. Bob Hutchinson for your wonderful and informative presentation. Happy Mother's Day to everybody, and thank you everyone for joining our meeting today. We hope to see you again next week, Thursday. Our speaker will be Mr. Michael Brooks from Direct. This meeting is now adjourned. Thank you, and stay safe, stay well, and see you again. See you next week. Thank you.
Bye-bye.
Bye-bye.
Happy birthday, Mindy.